Hello aspirants, welcome back to Daily Current Affairs Analysis by Civics Central IAS, where we break down the most relevant and high impact topics from the UPSC CSE prelims perspective using the reverse engineering technique, which is the core approach of Civics Central IAS, where we analyze previous year questions to identify the trends and also predict the potential areas of focus. Now, displayed below are the key topics which we'll be covering today. Well, let's begin. If we see the first article, it says that the National Human Rights Commission, in short the NHRC, on Thursday took summons cognizance of reports regarding the death of two persons after inhaling the toxic gas while cleaning a septic tank in Nandigram block in Purba Mednipur district of West Bengal. Now for prelims, here the important topic to know is about the Human Rights Commission. Now, but before knowing about the National Human Rights Commission, let's see what are the human rights. See, human rights are the basic rights and freedoms that every person is entitled to regardless of their nationality, race, gender or religion. And further, these rights are fundamental and universal, meaning they apply equally to all the human beings, right? Now, they also include essential freedoms such as the right to life, freedom of speech, equality before the law, freedom from discrimination, and also access to education and health, etc. And in India, the protection and promotion of these human rights are ensured by the National Human Rights Commission, that is NHRC. And this NHRC is an autonomous statutory body established specifically for the purpose for protecting the human rights. And this NHRC works to safeguard and uphold the human rights, ensuring that every individual's dignity and freedom are respected. Now further, let's see the NHRC establishment, its main objectives, what are its functions and powers. Well, the NHRC was set up under the Protection of Human Rights Act 1993 with the objective of protecting the rights of individuals guaranteed by the Indian Constitution or also by the international human rights treaties. Now, in other words, we can simply tell it ensures that people's fundamental rights are respected and upheld. Now, moving on to its functions and powers, the NHRC has several important responsibilities. Like firstly, it conducts inquiries and also investigations into human rights violations, particularly those involving the public servants or negligence by public authorities. And in addition to that, the NHRC can also take up cases on its own known as suo motu action, especially when sensitive issues come into light through media reports or other sources of information. Moreover, it issues recommendations and advisories to the government suggesting relief measures for the victims and prosecution for the violators. But not only that, the NHRC also visits the prisons and detention centers to check on living conditions and ensure that human rights are being respected. Furthermore, it conducts research and awareness programs to educate people about the human rights and also to ensure justice delivered swiftly. The NHRC even recommends the setting up of human rights courts for speedy trials. But however, like any other institution you take, the NHRC also has its own limitations and criticisms. So such that one major limitation is that it has no enforceable power. This means, although it can recommend actions, it cannot enforce its decisions. And the other backward is its jurisdiction restrictions, as it cannot investigate matters older than 1 year, which can delay justice in some cases. And also additionally, the NHRC has no power over armed forces and can only seek a report from the government if human rights violations by armed forces are alleged. Now lastly, its financial and administrative dependency is on the central government, where it affects its autonomy and also the independence. Now in conclusion, the NHRC plays a very crucial role in protecting the human rights in India by investigating the violations, raising the awareness and also providing the recommendations. But despite its limitations, it remains a vital institution dedicated to promoting justice and ensuring the protection of human rights. Now, here is a PYQ for you. It says that other than fundamental rights, which of the following parts of the Constitution of India reflect or reflects the principles and provisions of the Universal Declaration of Human Rights 1948? Now here, if we see the statements, it's like preamble, directive principles of state policy, and also fundamental duties, and it is asking us to select the correct answer. Okay, see. The preamble of Indian Constitution embodies the ideas of justice, liberty, equality, and fraternity, which are aligned with the Universal Declaration of Human Rights. Right? And so that it is reflecting the principles of dignity, freedom, and equality mentioned in the Universal Declaration of Human Rights. So, preamble is the correct statement. Now, further, we are having the directive principles. So, these are also aimed at promoting the social justice, economic welfare, and also the cultural harmony, similar to the socio-economic rights in the Universal Declaration of Human Rights, such as like right to work, education, and also the standard of living adequate for the health and well-being. So, this is also correct. Okay. And also, if we see the fundamental duties, it emphasizes the respect for the constitution, promotion of harmony, protection of environment, and preservation of culture, resonating with the Universal Declaration of Human Rights. So, this is also correct. Therefore, the three statements are correct, and the answer is 1, 2, 3. Now, if we see the other question, it says that consider the following organization or bodies in India. And the options are National Commission for Backward Classes, National Human Rights Commission, National Law Commission, National Consumer Disputes Redressal Commission. Now, it is asking us to identify which are the constitutional bodies in the given. Okay, let's answer this. First, if we take the National Commission for Backward Classes, yes, it is a constitutional body as it is mentioned under Article 338B of Indian Constitution through the 102nd Constitutional Amendment Act of 2018. Where its purpose is to investigate and monitor all the matters relating to the safeguards provided to the socially and educationally backward classes, right? Therefore, it's a constitutional body. Now, if we see the NHRC, as we discussed earlier, it is not a constitutional body, but it is a statutory body. Fine. Next, Law Commission. Law Commission is also not a constitutional body as it is constituted by the Government of India to provide the recommendations for the legal reforms. Therefore, it is an advisory and non-statutory body. Remember this. And now, if we see the National Consumer Disputes Redressal Commission, it is established under the Consumer Protection Act of 1986. So, it is a statutory body, not a constitutional body. So, the answer here is only one, that is the National Commission for Backward Classes, right? Now, moving to the second article. See, the second article says that the Supreme Court on Tuesday directed states with remission policies to consider the premature release of prisoners even if they don't apply for the remission beforehand. Now, in this context, for prelims, it is important to know about the remission. Now, what is remission? See, simply, it is nothing but reduction of length of a prison sentence without changing the nature of punishment. To say in other words, it allows a prisoner to be released earlier than the original sentence, but it does not change the fact that they were convicted. They are convicted, but here the prison sentence, that is the length of the prison, is changing without changing the nature of punishment. Right? Now, if we see, the remission is a form of clemency or leniency given to convicts based on their good behavior, completion of certain rehabilitation programs, age, health conditions, or also some other specific criteria which is set by the government. Now, here it is important to note that remission does not mean the prisoner is declared innocent. Instead, it simply shortens the duration of imprisonment. For example, see, if a person is sentenced to 10 years in prison, but due to good conduct or other qualifying factors, they receive a 2 years of remission. That means they would be released within 8 years instead of 10 years. Well, okay. See, now in India, the power to grant remission lies with the state governments under specific provisions like Section 473 of BNSS and also Section 432 of CRPC, which empowers the state governments to grant remission at any time with the discretion to impose conditions on convicts such as regular reporting to a police officer, and if these conditions are violated, the remission can be cancelled and the convict may be rearrested without a warrant. Right? Remember, he can be rearrested without a warrant. However, there are restrictions for life sentence convicts under Section 475 of BNSS and also Section 433A of CRPC, which state that remission cannot be granted before 14 years of imprisonment for crimes punishable by death. Further, the process of remission usually begins when the convict submits an application, but recently the Supreme Court ruled that it is no longer mandatory in certain situations where a remission policy is in place. So, in the year 2025, the Supreme Court revisited its stance on remission by considering two significant judgments from the year 2013, that is, Sangeet and ANR versus State of Haryana, and also the Mohinder Singh versus State of Punjab, which held that remission could not be granted suo motu, that is on its own, by the state, but only through an application by the convict or on their behalf. However, the SC revised this view due to the state remission policies that set specific eligibility conditions, and it ruled that states are obligated to consider every eligible convict's case under these policies, as failing to do so would be arbitrary and discriminatory. And also, it violates the right to equality under Article 14 of the Indian Constitution. Moreover, the court highlighted that some state prison manuals require prison superintendents to initiate the remission proceedings, showing how the remission policies are practically applied. And this ruling emphasizes the importance of fairness and also the consistency in the remission process across the different states. Now, moving to the next article, it says that incarcerated Qadar Sahib MP Amritpal Singh on Wednesday moved to the Punjab and Haryana High Court to attend the ongoing parliament session as he loses his seat because of his prolonged absence from the house. Right? This is the article. Now, in this context, let us know about Article 101 about Clause 4 of the Indian Constitution, which is dealing with the attendance of members of parliament. And it addresses the situations where MPs are absent for the long term. So, it states that, that is the Article 104 of Clause 4 states that if an MP is absent from all sittings of the Parliament for 60 consecutive days without the permission of the House, their seat may be declared vacant. Now, furthermore, this provision is particularly relevant for MPs who are unable to attend due to various reasons, including the imprisonment, as seen in the case of Qadar Sahib MP Amritpal Singh. So, it is important to note that 60-day period excludes any time when Parliament is prorogued, that is temporarily suspended or also adjourned for more than 4 consecutive days, ensuring that the calculation is based only on the actual sitting days of the Parliament. Right? Clear? Now, see, further, MPs who need to be absent for long periods can apply for leave by writing to the Committee on Absence of Members from Sitting of the House, which reviews the request and also makes a recommendation to the House. And also, MPs often request leaves due to illness, personal matters or imprisonment, as was the case with the Atul Rai, who is a former MP who was granted permission to remain absent for 23 consecutive sittings due to being in the jail. And also, this provision highlights the balance between maintaining the parliamentary discipline and ensuring fair representation for constituents and even in also the exceptional circumstances. Now, moving to the next article, it says that disability rights activists in Delhi are building a coalition to get a key provision of Digital Personal Data Protection Act 2023 dropped or amended. And also, the Section 9, Clause 1 of the Act has clubbed the children with persons with disabilities to mandate that even in cases of disabled adults who have the legal guardians, consent for use of any personal data must be obtained from the guardian concerned. Now, see, in this context, it is important to know about Digital Personal Data Protection Act 2023. So, it is a legal framework introduced in India to safeguard the personal data and also ensure that it is shared only with the individuals concerned. And it also regulates the processing of digital personal data to protect the individual's privacy in the digital age. And this law is applicable to the digital personal data processed within India, whether collected online or offline and later digitalized. But also, see, it also applies to the data processing outside of India when it involves providing goods or services to the data principals within India. Right? Now, see, the Act originated from the expert committee which is reported by Justice B.N. Sri Krishna and was initially proposed as the Personal Data Protection Act in the year 2019. And if we see the key features, One of the key features of this act is the right to data protection, which grants individuals the right to access, correct, and also erase their personal data, ensuring they have the control or their personal information. Now, this act also mandates explicit consent before data processing with clear consent forms and easy withdrawal options. It also emphasizes the data localization, requiring sensitive personal data to be stored and processed within India to enhance the data security. See, the Act also differentiates between the data fiduciaries who collect and manage the personal data and also the data processors who process data on behalf of the data fiduciaries. Now, to ensure the compliance, the Act establishes the Data Protection Board of India, which is an independent body which is responsible for enforcing the regulations and handling the grievances. It also has the power to impose penalties for the non-compliance cross-border data transfers which are permitted only to the country notified by the central government, ensuring that secure international data flow. And also, see, if there is case of data breaches, it is mandatory to notify the affected individuals and also the DPBI, that is the Data Protection Board of India. Further, the Act imposes strict penalties including up to 250 crores for data breaches and also 500 crores for the repeated violations to ensure the accountability. Now, if you see the Section 9 Clause 1 of the DPDP Act 2023, there are special provisions for vulnerable groups requiring consent from parents or guardians for processing the personal data of minors and also the persons with disabilities. However, this provision has been criticized by disability rights activists who argue that it undermines the autonomy of adults with disabilities who are legally competent to provide the consent themselves. Despite these controversies, the Digital Personal Data Protection Act 2023 marks a significant step towards strengthening the data privacy and also security in India. Now, let's see a UPSC previous year question. Now, it says that right to privacy is protected under which article of the Constitution of India? And the given options are Article 15, Article 19, Article 21 and also Article 29. Okay, well, see, the answer is, it is Article 21. So, Article 21 of Indian Constitution states that no person shall be deprived of his life or personal liberty except according to the procedure established by law. Now, see, if we recall to the 2017 Supreme Court of India judgment, that is K.S. Puttaswamy versus Union of India, they declared that the right to privacy as fundamental right under Article 21, interpreting personal liberty to include the right to privacy. And this judgment emphasized that privacy is intrinsic to right to life and also the personal liberty. Therefore, the answer is right to privacy is protected under Article 21. Now, here is another question. Well, now I want you to answer this question in the comment section. Now, if you see the next article, it says that a team of researchers from Indraprastha Institute of Information Technology, Delhi, that is IIIT Delhi, have come up with the AI-powered data integration and also the predictive analytics tools to understand the patterns of antibiotic resistance in real time, enabling agencies to act on them speedily. Now, as a part of this collaboration between IIIT Delhi, Tata 1mg and also the Indian Council of Medical Research and Scientists, the AI-driven tool that is AMR Sense has been deployed to use routine data that is generated in hospitals to generate the accurate and early insights on the antimicrobial resistance at the global, national and also the hospital levels. So now, in this context, it is important to know about antimicrobial resistance. Now, what is antimicrobial resistance, in short the AMR? It occurs when microorganisms such as bacteria, virus, fungi and parasites develop the ability to resist the effects of antimicrobial drugs including the antibiotics, antivirals and also the antifungals. And this resistance makes standard treatments less effective, leading to the increased mortality, prolonged illness and also higher medical cost. It also threatens the progress of modern medicine, impacting procedures like surgeries and also the chemotherapy, which rely on effective antimicrobial drugs for the infection prevention. Right? Now, moving forward, see, if we see the causes The primary causes of AMR include the overuse and misuse of antibiotics in humans and livestock, which accelerates resistance development. Additionally, the poor infection prevention and also the control practices such as inadequate hygiene and healthcare sanitation contribute to the spread of resistant microorganisms. And now, another significant factor is the lack of new antibiotics, as the development of new drugs has slowed down due to high research cost and also the low profitability. Furthermore, the other cause is the environmental contamination, such as improper disposal of antibiotic residues also contributes to the AMR. Now, in response to the growing threat of AMR, AI-driven tools are playing a crucial role in AMR surveillance and control, like the predictive analytics and also the pattern recognition powered by the machine learning models are used to analyze large data sets and identify the resistant patterns, helping to predict future outbreaks. Like for instance, organizations like the CDC, that is the Centers for Disease Control and Prevention, and also the World Health Organization, that is WHO, utilize the AI models to monitor resistant trends. And also additionally, the real-time surveillance and monitoring are achieved through the AI systems that collect and also the analyze data from hospitals, laboratories, and if you take your public health databases as seen in the WHO's GLASS method, that is GLASS stands for Global Antimicrobial Resistance and Use Surveillance System, which integrates AI for real-time AMR tracking. Like AI-driven diagnostic tools enable rapid pathogen identification and resistance profiling, leading to targeted treatments. For example, AI-based PCR, that is polymerase chain reaction systems, provide quick antimicrobial susceptibility testing. And also, AI is used in genomic analysis, where it examines the genomic sequences of microorganisms to detect the resistance genes, as demonstrated by the CART, that is the Comprehensive Antibiotic Resistant Database. Moreover, the AI is also revolutionizing the drug discovery by identifying the novel antimicrobial compounds and also repurposing existing drugs. For instance, the DeepMind's AlphaFold is being used to discover drugs targeting the resistant bacteria. Now, in conclusion, globally, several government and international initiatives are in place to combat AMR, such as like the World Health Organization has developed the GLASS system integrating AI for the global AMR surveillance and reporting. And in India, the National Action Plan on AMR aims to strengthen AMR surveillance, awareness and research with the Indian Council of Medical Research, that is ICMR. So where AMR surveillance and research network leveraging AI for resistance pattern analysis and also the data integration. Now, these initiatives highlight that the global collaboration and technological advancement needed to effectively tackle the growing challenge of antimicrobial resistance. Now, let's see a UPSC PYQ. It says that which of the following are the reasons for the occurrence of multi-drug resistance in the microbial pathogens in India? Now here it is, genetic predisposition of some people. It is incorrect. Because, see, multi-drug resistance in microbial pathogens is not caused by the genetic predisposition on humans. Instead, it occurs due to adaptation and mutation in the microorganisms as a response to antibiotic exposure, right? So, human genetics do not influence the resistance developed by the pathogens. So, this is incorrect. Now, the other statements are taking incorrect doses of antibiotics due to cure diseases, using antibiotics in livestock farming, multiple chronic diseases in some people. Yes, these three statements are correct. See, if you see, incorrect dosage or incomplete antibiotic courses can lead to partial killing of bacteria, allowing the remaining bacteria to develop the resistance. This misuse is a major cause of multi-drug resistance. And also, using antibiotics in livestock farming. If we see, the overuse of antibiotics in livestock farming promotes the resistance as residues enter the food chain and environment, leading to the cross-resistance in human pathogens. So this is also correct. And people with chronic diseases often require long-term antibiotics treatments, right? Therefore, increasing the risk of developing resistant strains due to the prolonged exposure. So here it is, 2, 3, 4 are correct. Option D is correct. Now, moving to the next article, it says that Delhi Chief Minister Rekha Gupta on Thursday said that the cabinet has decided in its first meeting to implement the Ayushman Bharat Yojana and also to table 14 pending Controller and Auditor General reports in Delhi Assembly. Now, in this context, let's talk about the Ayushman Bharat. Know that Ayushman Bharat is a flagship health scheme launched by the Government of India as recommended by the National Health Policy 2017. Now, if we see the aim, it is to achieve the universal health coverage, ensuring that every citizen has access to quality health care without the financial hardships. And this initiative is designed to meet the sustainable development goals with the underlying commitment to leave no one behind. And also, the scheme adopts a continuum of care approach, which means it focuses on providing the comprehensive healthcare services throughout an individual's life. Further, it consists of two key components. First is the health and wellness centers and also other is the Pradhan Mantri Jan Arogya Yojana. Now, let's talk about them in detail. Firstly, talking about the health and wellness centers, it focuses on providing preventive, promotive and also the primary healthcare services, ensuring that basic health services are accessible at the grassroots level. Now, on the other hand, Pradhan Mantri Jan Arogya Yojana is the largest health assurance scheme in the world, aiming to provide a health cover of rupees 5 lakh per family per year for secondary and tertiary care hospitalization. And the scheme targets over 12 crore poor and vulnerable families, approximately 55 crore beneficiaries, representing the bottom 40% of the Indian population. And the eligibility criteria for PMJ, that is the Pradhan Mantri Jan Arogya Yojana, are based on the deprivation and occupational categories identified in the socio-economic caste census 2011 for both rural and also the urban areas, ensuring that most needy and vulnerable families are also included. Now, it is worth noting that PMJ was earlier known as National Health Protection Scheme before it was renamed. Now, it is also subsumed the Rashtriya Swasthya Bima Yojana, which has been launched in the year 2008. Also, the PMJ is fully funded by the government and the cost of implementation is shared between the central and state governments, ensuring the comprehensive financial backing for the scheme. It also offers coverage at both public and private empaneled hospitals across India, enhancing the accessibility and choice for the beneficiaries. And also, the scheme provides comprehensive coverage including the pre-hospitalization expenses for up to 3 days and post-hospitalization expenses for up to 15 days, which cover the diagnostics and medications. And additionally, there are no restrictions on family size, age or gender, ensuring that every eligible family member can benefit from the scheme. So, all the pre-existing conditions are covered from day one itself, providing complete health security. Now, moving to the next article, it says that Supreme Court on Thursday stayed a Lokpal order bringing High Court judges under its jurisdiction while terming the top anti-corruption ombudsman interpretation very disturbing. So, if we see the case, recently on January 27, 2025, the Lokpal issued an order stating that it has the authority to entertain complaints against sitting High Court judges, interpreting that such judges fall under the definition of public servant according to Section 14 of the Lokpal Act. Now, this order sparked a lot of debate because it raised questions about the independence of the judiciary. Now, in response to this, the Supreme Court of India took summatory cognizance of this order, which means it acted on its own without any complaint being filed, where a special bench comprising Justices B.R. Gavai, Suryakant and Abhay Oka expressed the serious concerns about this order, arguing that it could undermine the independence of judiciary. So, as a result, the Supreme Court stayed the Lokpal's order and issued notices to the Union Government and Lokpal's office, highlighting the need to maintain a balance between accountability and judicial independence. Now see, in this context, it is important to know about Lokpal for the prelims context. Now, what exactly is this Lokpal? Know that Lokpal is a statutory anti-corruption body established to inquire into allegations of corruption against public officials. Its main mandate is to ensure accountability and transparency in public administration. Also, it covers a wide range of public functionaries, including the Prime Minister, Union Minister, Members of Parliament, and also the central government officials. Now, let's look at the organizational structure of Lokpal. See, the Lokpal consists of a chairperson and 8 members, out of which 4 are judicial members. So, to ensure the diversity and representation, at least 50% of the members must be from SC, ST, OBC, minorities and women. And this structure ensures the Lokpal is inclusive and represents different sections of society. Further, the jurisdiction and coverage of Lokpal are extensive. It can investigate allegations of corruption against the Prime Minister, except in the matters related to the international relations, security, like public order, atomic energy and space, and also the union ministers and members of parliament, central government officials from Group A, B, C and D, and also public servants in autonomous bodies including the chairpersons, members, officers, and also the directors of boards, corporation societies, and also the trust that are established by an act of parliament or funded by the government. And also remember here, it also covers NGOs and trusts that receive the foreign contributions above 10 lakh rupees, ensuring that comprehensive coverage of public entities. However, there are special conditions for investigating the Prime Minister, where the Lokpal can initiate any inquiry if the full Lokpal bench considers it and at least 2/3 of members should have been approved. And this safeguard ensures that position of Prime Minister is not misused for the political motives while maintaining the accountability. Now, let's talk about the powers of Lokpal, which are quite extensive. Firstly, it has the power of a civil court, enabling its inquiry wing to summon witness, examine evidence, and enforce the production of documents. Second, Lokpal can confiscate assets, proceeds, and benefits obtained through the corruption, ensuring that ill-gotten wealth is not enjoyed by the corrupt public servants. Next, it can recommend the transfer or suspension of public servants involved in corruption allegations, preventing interference in ongoing investigations. And also, it safeguards the evidence. For example, Lokpal has the power to prevent the destruction of records during the preliminary inquiries itself. And lastly, it also has supervisory authority over the CBI in cases referred to it, allowing the Lokpal to direct and oversee investigations effectively. Now, to sum it up, Lokpal is a powerful anti-corruption body in India that plays a crucial role in ensuring the transparency, accountability, and also the good governance. So, its extensive jurisdiction and powers make it an essential institution in the fight against the corruption. However, the recent controversy about its authority over the High Court judges brings to the light that the delicate balance between accountability and judicial independence should be maintained. Now, moving forward to the last article of the day is that, according to the sources, the centre has begun consultations on leasing over 10 airports under the public-private partnership model. Now, in this context, let's talk about the public-private partnership, that is PPP model. Know that it is a collaborative arrangement between the government and the private sector to finance, build, and also operate infrastructure projects or public services. So here, if you can see, it is between the partnership between the public and private sectors, right? Now, this model is designed to leverage private investment and efficiency while ensuring the public oversight and regulation. If you see the primary objective of this model, it is to reduce the financial burden on the government by utilizing private investment and expertise while ensuring the efficient delivery of public goods and services. Recently, the central government initiated consultations on leasing over 10 airports under the PPP model, aiming to enhance infrastructure and operational efficiency through the private participation. So, this PPP model has some risk and responsibility, and they are shared between the public and private sectors, ensuring a balanced approach to financial, operational, and construction challenges. And these partnerships are typically long-term contracts spanning some at least up to 20 to 30 years, ensuring the stability and sustained investment. And also, the revenue sharing is another key feature where profits are either shared or generated through the user charges, maintaining the financial viability. There are different types of PPP models tailored to some specific project needs. First, if we see the build, operate, transfer model, which allows the private entity to build and operate the project for a fixed period, and after that, it transfers the ownership to the government. And in contrast, the build, own, operate model, which allows the private sector to build, own, and operate the project without transferring the ownership. And now, another model is the design, build, finance, operate, where the private sector designs, builds, and finances and operates the project, earning the revenue through the user charges. And lastly, it is the hybrid annuity model, which is a unique approach where the government and private entity share the investment burden, where the government provides fixed payments during the construction, while the private entity receives annuity payments during the operation, ensuring a balanced risk reward structure. Further, if we see some successful implementations in the PPP model by India, there are several infrastructure projects, including the National Highways Development Project under the BOT model, and also the Delhi Metro Railway Corporation through a joint venture PPP model, and the modernization of Delhi and Mumbai international airports with the private consortiums. Now, seeing this conclusion, the public-private partnership model has emerged as a powerful tool for developing infrastructure and delivering the public services in India. So, by leveraging the private investment and efficiency, it effectively reduces the financial burden on the government while ensuring the high quality public services, with the government's plan to privatize over 10 airports under the PPP model. However, to maintain the public interest, it is crucial to ensure transparency and public oversight throughout the process, balancing efficiency with accountability. With this, we conclude today's current affairs video and we'll be back tomorrow with another video. Thank you.